Good morning, everyone. Welcome to our first Construction and Engineering webinar for 2023, our spring update. My name is Catherine Andrews. I'm a partner in the Construction and Engineering team here at Birketts. And thank you all for joining us this morning. Next slide, please. So hopefully most of you are familiar with Birketts and have attended some of our previous sessions, but in case you haven't, there's just a bit of information here at a glance for you on the slide. We are now a top 50 full service law firm. We've got 5 offices across the east of England and London, which is very soon to be 6, with our new office opening in Sevenoaks at the beginning of next month, which we're all very excited about. Next slide, please. Just wanted to take a moment to introduce our speakers for today. So first off, we have John Fawcett. We're very pleased to introduce John to you all. He's a new recruit to our disputes arm and has joined as a senior associate. So please feel free to contact John in relation to all things contentious. Those of you who are familiar with the format of our sessions will know we like to include a guest speaker. And today our guest speaker is Tim Boucher, who's kindly agreed to join us for today's session. Tim is a director at Oxbury Chartered Surveyors, and he'll be looking at a recent survey that Oxbury have undertaken looking at key themes in the industry following a survey of a number of main contractors working in the region. And last but of course not least, we have Sarah Pryor, who is a trainee legal executive in our team, and she's going to review recent case law for us towards the end of the session. Welcome to all of you, and thanks especially to Tim for joining us today. Next slide, please. Thank you. So briefly on the agenda, we've had quite a lot of feedback saying people would like a look at adjudication. So John is going to take us on a bit of a whistle-stop tour through the adjudication process first. We do a lot of adjudication work here at Birketts, so hopefully we'll have some useful insights for you. We'll then move on to Tim, who will take us through the Oxbury Regional Contractor Survey, and then Sarah will follow up with the case law update. Finally, we'll come back together for a Q&A session with the panel. There will be an opportunity to put your questions to the panel through the chat function in the GoToWebinar portal. The questions come through to me and not to panelists and other delegates, and they're entirely anonymous, so please don't be shy in raising your questions. We've had a few through in advance as well, thank you. So we will get through as many as we can, but obviously if we don't touch on them all, we can come back to people afterwards with any follow-up. So just some final housekeeping points. The session is being recorded and will be circulated to delegates afterwards, along with a copy of the slides. These should be with you in the next week. And also the webinar and our previous webinars can all be found on our Birketts YouTube channel, should you wish to listen to any points again. So without further ado, I'm now going to hand over to John to talk us through the adjudication process. Thanks, John.
Thanks, Catherine. So as Catherine said, we've had quite a lot of feedback from people who are looking for an overview of the adjudication process. So what this will be is a whistle-stop tour through the process. For some of you who've been through the ringer of an adjudication or two, this might be a bit of a lesson in sucking eggs, but hopefully it's a useful grounding for those of you who are less familiar and a useful recap for those of you who do know the game. So starting from the beginning, the history of adjudication, it all came about from the Latham report. Off the back of the late 80s recession, the government commissioned Sir Michael Latham to give a report into how the British construction industry could be made to function more effectively and give rise to fewer insolvencies. His report, entitled Constructing the Team, is the backbone of the provisions that have later come into force via the Construction Act. So the Construction Act came into force in 1998. It was supplemented by the Scheme for Construction Contracts, which sets out the fallback position for adjudication rules as well as payment arrangements. Critically, adjudication comes with this temporary finality concept. The adjudicator's decision is binding until either a court decides differently or the parties come to an agreement. It's a decision the parties can use, ideally to keep a project moving and to at least keep money moving through the industry. Perhaps the most surprising aspect that comes out of these reforms is the adjudicator's license to get it wrong. You can't usually sue an adjudicator for making a wrong decision unless they've done it in bad faith, and the court will usually enforce a decision which is simply wrong in law or wrong in fact. Getting it right is less important than getting it done. Next slide, please. So this is the basic setup that the Act requires. These set of provisions must be in every construction contract. To the extent that they're not, you will be forced to take them via the scheme. The key takeaways here from these are the ability to refer an adjudication at any time, and the strict time limits imposed, both in terms of how quickly the process needs to be started and also the tight deadlines for bringing it to a close. Next slide, please. So it's easy to see it in the words and not really understand what it means, but hopefully this timetable gives you a good insight into how it actually works. This is a worked example. Not all adjudications will be strictly adhering to these timescales, but they are pretty common. The first 3 steps on this board are set in stone. They are from the statutory provisions, and non-compliance with them will invalidate the appointment of an adjudicator. The stages in brackets don't always happen. So they're quite common, but they don't necessarily always happen. The adjudicator has a fair rein to give directions as they see fit in order to get the information they need to make a decision. So we don't always see those provisions, and sometimes indeed you have to be a bit careful what you wish for. I recall demanding to put in a surrejoinder in an adjudication on a Friday afternoon, asking for time until Monday lunchtime to do it, and the adjudicator kindly gave us the surrejoinder but demanded it be served by 4 o'clock on the Sunday. So be careful what you wish for. The meeting line is particularly rare. Some adjudicators do want a site visit, but a trial-like hearing is vanishingly rare. You need to make the case on the documents. So let's have a look at what those documents involve. So the next slide, please. So how do you start the process? Firstly, establishing the adjudicator's jurisdiction is going to be critical. You'll hear me use the word jurisdiction pretty much throughout the rest of this presentation. To do that, you've got to follow the process properly. First, you've got to identify whether or not there is a dispute between the parties that's capable of being referred, and it has to have crystallized. That's a fancy word for saying that it's been put between the parties. But sometimes we look at the circumstances and we do decide that before we start an adjudication, we need to send a letter to the other side just setting out the dispute. Other times, the ordinary dialogue between the parties during the project will have done the job. Next stage is to put together the notice. The adjudication notice is the foundation of the jurisdiction of the adjudicator. It needs to set out the scope of the dispute properly, although briefly at this stage, and it needs to be served. Generally, this involves following the contractual service provisions, but in the absence of those, it can be relatively complicated. The key to that is that it has to be served before you can seek the nomination of the adjudicator. So the next stage is to ask for a nominating body, usually, unless a particular adjudicator is specified in the contract, to nominate an adjudicator to deal with the adjudication. Now, they're usually set up to act pretty quickly, but it would be an unwise person who left it to the end of the strict 7-day timescale for the service of the adjudication notice to seek the appointment. Generally speaking, as soon as we're comfortable that we've properly served the adjudication notice, we will start the process for the nomination It only costs a few £100, and you really don't lose very much by getting it underway, even if payment comes out of the blue or a deal is done very quickly. It's always worth kicking it off. Next slide, please. So, shoes on the other foot. You've just received in an adjudication notice. An adjudicator has been appointed, and then the adjudicator has ordered the referral notice to be sent across. You get this beautifully crafted referral notice. The referring party has spent weeks, months possibly putting it together. It's got wonderful expert evidence and documents galore to back it up. You are then likely to get 7, maybe 10 days to respond to that as the responding party. So firstly, you need to check whether there's jurisdiction for that process to kick off, because if you can argue that there isn't, you might get yourself a bit more time if there has to be a flaw cured in the process. If you can't avoid it, you're going to have to get on, and you might need to look at cross claims as well. Cross claims are sometimes usable as a defence in adjudications, not always, and it's always a bit of a debate with the other side and sometimes with the adjudicator. So it's usually wise to try and get on with this as soon as possible. Next slide, please. So you've been through the process of the referral, the response, and you may even have gone through the process of some rejoinders to rejoinder, even beyond that. Then you get delivered a decision. Critical elements of the decision are that it must be delivered within the period for the adjudication. There is some limited scope for it to be delivered shortly afterwards, providing the decision was made during the timescale, but that tends to lead to enforcement becoming rather more tangled. The decision also needs to give reasons. It can't just be a figure. So the adjudicator can't just say you need to pay X. They do need to back up Y. They can't set that out after the process either. It's also very difficult to challenge errors in the decision. So if you've got some minor typos, transposition of numbers, that can be sorted out administratively. But if you don't agree with the decision and you think you've got points you could take, you are probably at a loss. You're not going to get that cured after the fact. Next slide, please. Saying you might not be able to get it cured, there is sometimes a way. So the adjudication is generally the final word until the court decides otherwise. One way to get the court to decide otherwise is to bring a Part 8 claim. These are narrow issues with not vast quantities of witness evidence, certainly no live witness evidence to be heard. Often they're matters of documents. The process is quite straightforward. You make a claim and the court will list it as urgent business. You can do that either during the process or after the adjudication, depending on the needs. But it is a restricted right to do this. The court doesn't like people using this too widely, so it can be quite resistant to making orders off the back of Part 8 claims. So we do have to look very carefully at whether it's appropriate to do it in the particular circumstances. Next slide, please. So most adjudicators' decisions are respected. That's what the court wants to happen as well. So it's set up a process to ensure that the parties can enforce adjudicators' decisions quickly and efficiently. The process is set out on the slide that you've got there. I won't just read it through, but broadly it's a claim followed by a further application that's issued at the same time as the claim, and it leads to a hearing generally about a month after the claim is issued. So that's unbelievably quickly for court processes. At that hearing, the court will hear arguments as to whether the decision should be enforced. The grounds to resist enforcement are really quite narrow. Broadly, you're looking at either an argument that the adjudicator lacked jurisdiction, or that there was some breach of natural justice in the way the decision was reached. Those are pretty narrow options. If the court does decide on enforcement, you might have a further chance, a further bite of the cherry to try to stop the enforcement by way of a stay of execution. Generally, that's where the court is convinced that the receiving party is not going to be able to make good anything that they've received that they shouldn't ultimately have done so. It is quite hard to convince the court to stay adjudication enforcements. It doesn't happen all that often, although it is tried all the time. I think Sarah, in fact, has an update on this, which she might come to a little later. So I'll leave that to her to discuss a little further. One thing to say is, if the decision is enforced, you should expect a harsh costs order off the back of it. The court will usually order that the paying party pays all of the receiving party's costs, and it's not uncommon to see £15,000–20,000 worth of costs waved through without much scrutiny. So that brings us to the end of what is really a whistle-stop tour. Hopefully it's given you all some insight. I'm sure it's raised a lot of questions. If you'd like to put some of those in the chat, I'm sure that we'll have a bit of time to answer them at the end. But for the moment, I'll hand over to Tim to talk about the Oxbury Regional Contractual Survey.
Thanks, John. Great. Okay. So just a quick introduction. I'm Tim Boucher. I'm a director at Oxbury Chartered Surveyors. We operate throughout East Anglia and down in London as well. If we can move on to the first slide. Just to give you a bit of an introduction, this is our 8th annual survey. It's something we've been doing for a while now, interviewing and surveying local contractors or regional contractors. These mix from both national and local small contractors, but what we're focusing on is the projects and the work they're delivering in East Anglia. Just to give a bit of a figure, really, just to put it into context, the 16 contractors who've responded, their combined turnovers are around 1.6 billion forecast for 2023. So quite a big turnover, really, and quite a big part of our economy. Next slide. So these are the contractors we spoke to and responded to the survey. Just a note, really, just to say thanks to those guys. Obviously, if they didn't respond, they wouldn't have much to say today. So again, it wouldn't be possible without them. So next slide. And just a bit of a explanation as to why we do the survey. I guess the construction industry has been through a fairly prolonged period of uncertainty in recent years. We've had Brexit, we've had political challenges, both with a general election some time ago now, but various prime ministers. Then we had COVID-19, and then just over a year ago we had the start of the war in Ukraine. All of these have had a sort of an impact on our industry to various degrees. When we did the survey a year ago, we didn't really know what the impact of the Ukraine war would be, and some of that comes out later in the presentation in terms of what actually happened. So we will be comparing back to where we were a year ago and the outlook then and actually what ended up happening. Next slide. Just to give you a bit of an agenda for my section, we're going to talk quickly about economics and the contractors we've spoken to, their turnovers and the sectors that they're working in. A little bit about procurement and tender prices, then some of the key challenges that contractors are currently facing. And then we've got a new section into the survey, which is touching on sustainability, which is obviously key at the moment. And that has replaced what perhaps in previous surveys we were discussing COVID and things like that. And actually there is no mention of COVID in this presentation, you'll be pleased to hear. and then looking ahead at the future and the outlook and how trying to wrap it all up together, please. Next slide, please. Next slide, please. Okay, so this is just looking at last year's survey and the contractors that we spoke to at the time, just to make a bit of a note there in terms of what the impact of the COVID pandemic in 2020 started. Contractors did see a drop off in turnover, and then they were forecasting a really healthy return to form, really, with a sort of 13% drop in 2020, and then a forecast 15% increase into 2021, 12% into 2022, and 6% beyond into 2023, which is where we sit now. Obviously, there was a quick rebound there. If we can move on to the next slide. So what are the contractors saying now? Actually, what we're seeing here is that turnover in 2022 was actually much higher in terms of its increased actually 15% over the forecast, and then forecasts into 2023 are stronger than they were previously predicted, with 11% rise forecast and 2024 a 10% rise. Overall, that is some significant rise in turnovers across these contractors, and you can see from 2020 their combined turnovers at just under 1.2 billion in the space of 4 years, going up to over 1.7 billion. So there's a significant increase in work. Obviously, some of that increase is picked up in inflation and the rising material costs, but nonetheless, there is a massive increase in work expected. Next slide, please. So turnover secured. This has been fairly consistent in all of our surveys in terms of the work secured for this current year, where contractors have about 80% of their work confirmed on average, and looking into 2024, just under 40%, with 36% on average secured. That's a slight drop of 3% on the previous survey, which is fairly insignificant. And the other thing just to note really is that the value of those projects has changed quite a bit in the last year. We were seeing that the majority of projects were sort of in the under £5 million mark, and then the next proportion in 5 to 20 million. We've seen that change, so there are less projects at less than 5 million, and quite a significant increase in projects between 5 and 20 million. Again, some of that is because the prices have risen, but equally I don't think that explains all of that, and actually I do think perhaps some of the projects are getting larger. In terms of forecasts, tender opportunities, 60% of the contractors forecast there will be less or no change in the tender opportunities in 2023 versus 2022. So that is something to bear in mind, that whilst they are forecasting some major sort of increases in turnover, they're also potentially predicting a drop in tender opportunities. Next slide. So which sectors are likely to be the busiest and least busy? This has been really consistent again, and almost replicates what happened in the 2022 survey. The residential sector is still seen as the busiest sector in our region, with education and health following on from that. In terms of least busy, commercial, and I guess commercial offices is picked up in this, is seen as the least busy, and that has been the same for a number of years now, and retail, which is not surprising given sort of the horror stories we read in the press about various retailers. And there was a story today about John Lewis, I think, making a further loss. And then ironically, we've also got education, where some contractors were predicting education being the least busy sectors, and others predicting it would be in the busiest. Next slide, please. Next slide. Okay, so tender price indices. So I've actually gone back here a couple of years, because I think this is some interesting statistics if you're into that sort of thing. In 2021, we were the contractors, which are in grey, and BCIS are in grey, and the contractors are in red. This was their forecast increase in tender prices looking ahead. So in 2021, 2022, and 2023, they were forecasting somewhere between 3 and 4% rises in tender prices. This all at the time felt fairly sustainable and was perhaps what we were used to seeing, and that was sort of coming out, as I say, of the 2020 year, pandemic year. If we move on to the next slide, in 2022 these changed quite dramatically. They doubled in terms of forecast tender price rises in 2022. I'll come back to that in a moment. But forecasts further on into 2023 and 2024 were much higher than they were the year before. What we actually did this year was we asked all the contractors what they felt the actual prices had risen by during 2022, because there's been lots of figures bandied around about how material prices were at a 40-year high. On average, the contractors said that the prices had risen 13.5%, and those answers sort of vary anywhere between 10 and 20% across all the contractors, which is quite a dramatic increase in prices, really. If we can move on to the next slide. I guess the context of that is that in 2023 results, the forecast rise in tender prices, and bear in mind the red columns are what contractors are saying, and the grey ones are what the BCIS are saying, and perhaps contractors are perhaps not the most modest of parties in these things, and perhaps predicting higher rises than the rest of the market. But nonetheless, if you take the 5.9% rise and add that to the 13.5% that we saw last year, you're getting on for 20% increase in construction costs over a 2-year period, which is quite phenomenal, really, considering the previous few years we had seen little or no rise. And then again, going forward, still rises of 4 and 3.6% into 2024 and 2025. Next slide. So what are the key pressures that the contractors are facing? Probably no great surprise, but I think it's worth mentioning labour shortages is the key issue and key pressure, getting hold of labour. A lot of this was sort of seeded back in from Brexit, where a lot of the migrant labour and skilled labour that was working on the UK construction sites left. Second is inflation costs, which is obviously quite a current issue, and arose the last sort of 6 months, where the cost of labour, materials, energy and fuel has just spiralled, which is putting extra pressure on contractors. The third is material shortages, just physically getting hold of materials, and a lot of that has been driven by what's happening in Ukraine, but also still equally from Brexit in terms of getting materials into the UK. Interesting, number 4 is unrealistic budgets, and a lot of the contractors were saying that clients and perhaps quantity surveyors who are forecasting budgets are giving sort of unrealistic figures that contractors are unable to achieve, and that sort of sets off on the wrong foot in terms of moving a project forward, where it's perceived that the contractors have perhaps overpriced things, and in reality it's just that budgets are unrealistic. And then number 5 is supply chain failure, and that is in all levels, really. So subcontractors and suppliers going bust, really, and leaving main contractors to pick up the pieces. I think probably the unrealistic budgets and supply chain failure is a cause of the labour shortages, material shortages, and inflation costs. They all combine together to make those matters worse. Other things just to note is a lot of contractors mentioned that poor design in terms of tender information is also a pressure for them, and a race to the bottom, with contractors stood out there putting really low prices in, which are perhaps seen as unsustainable. What are the top 5 materials and trays that we might expect above average price rises or a lack of availability? Number 1 is bricks and blocks. This has been an issue now for a while. Mechanical and electrical plant and equipment is number 2. We've got concrete, steel, plasterboard and plaster also featuring there. And then others to note are cladding, insulation and carpentry. I guess you add all of those together and you've got most components of a construction project, but nonetheless there are obviously still some serious issues in terms of getting hold of materials. Next slide. Okay, so top 5 reasons why a contractor might decline a tender for a new project. I feel a little nervous saying that contract conditions are the top risk, sat in a Birketts webinar, so I won't dwell on that for too long, but obviously contractors perceive that too much risk transfer to them is seen as a major reason to decline a tender. Number 2 is the number of contractors on a list. Too many contractors will put off bidders. Obviously, the cost for a contractor to submit a tender is quite high, and obviously if they're up against 5, 6, 7 contractors, the chances of them winning are significantly less. So that's quite a key issue for them. Client risk, a client's reputation, their financial standing, or any existing relationships they may have with other contractors is a factor, which is sort of stating the obvious really, but equally contractors are nervous about clients that have potential risks in terms of making payments or the way they deal with contractors. The procurement route, despite 80% of the contractors we survey saying they would tender a single stage tender, in reality it still proves unpopular. And in reality, it's sort of we perhaps see it on a lot of the residential projects where it's perhaps less risky, but on some of the more sort of commercial projects, getting a single stage tender is unlikely in the current market and has been for some time now. And the location, which again I think is probably sounds fairly obvious in terms of contractors wishing to work in the locations they're based in, but actually with the issues in terms of subcontractors and the supply chain, I should imagine working with the suppliers and subcontractors they know well in their local area is more comforting for them. So again, location becomes more of an issue. And again, just to note there that poor design, contract duration, and poor tender documents are other reasons why contractors will decline a tender. Just a final point on this one, just to say that in 2022, 100% of the contractors were being more selective about the tenders they were responding to, whereas this year that's dropped down to 50%. So again, whilst contractors are busy, they are still looking potentially at, or being less selective about the tenders they'll look at. Next slide, please. Next slide. Okay, so these are some quotes that the contractors have put forward. I won't necessarily read all of them, but just to give you a bit of a heads up, really, just one of them is in terms of the current challenges faced by contractors. Insolvency is obviously a big issue for contractors with their supply chain. The ongoing war in Ukraine is linked to material and labour prices, a lack of skilled labour and resources, which is echoed by all contractors. An interesting one here, construction consultants maintaining professional standards, RICS, for example, when producing tender documents and time periods allowed. Too many are bowing to clients' unreasonable and uneducated requirements, which is no good for the industry. Obviously, I won't share who shared that one. Then we've got another one, which is talking about obviously 2022 being a hard year for contractors with the supply chain issues and inflationary issues caused by the war in Ukraine. But what they're talking about here is that actually when that war does come to an end, perhaps one of the biggest risks to the UK construction industry will be the rebuilding of Ukraine and its draw on materials, labour and everything else across Europe. And then just a couple, the sustainability agenda and legislation is just putting added pressure on the construction industry as things continue to change. Obviously, contractors need to adapt and be able to meet those changes in legislation, which means constant learning, changes in technology and how they're constructing projects. And then, which we touched on earlier, is project viability and just projects being unviable post-tender and due to lengthy negotiations and protracted value engineering procedures and things, which all relate back to perhaps unrealistic budgets being set by clients in the first place. Next slide. So trying to sort of summarize these in terms of what are the greatest challenges for contractors over the coming years. Skilled labour is clearly an issue. It's something we talk about a lot in the industry in terms of shortages of key trades, which is impacting on subcontractors and prices and availability. That's also true of the professional side of things. Material cost rises continue to fluctuate and rise. Subcontractor insolvencies, again, due to fixed prices, perhaps in 2020 and 2021, contractors are bearing the brunt of that now with the rises since then. The environmental agenda, there's obviously more and more pressure for greener building, greener construction, which is driving up costs and putting tighter restrictions on building performances, which is all adding to pressures on contractors. Next generation is just really about encouraging a generation in all professions to join the industry and how we train them and the challenges on getting people into the construction industry and perhaps its perception. And then, as always, really a race to the bottom and just a lot of clients still perceiving that the lowest price is the best price and not necessarily taking on board a contractor's other skills and attributes that they can bring to a project. Next slide, please. Sustainability. Okay, so we asked clients, are they seeing clients seeking to build more sustainably? 90% said that they were seeing that. Okay, that is the case. Next slide. And then we asked contractors as businesses, have they improved their own sustainability policies? And 75% of them have. This seems to have been on the agenda for lots of them for a long time in terms of looking to be carbon neutral, to meeting the new ISO 14001 requirements, and just generally just being more sustainable throughout. We did have a couple of contractors who weren't, and one did come back and say that they didn't perceive there was any commercial benefit in doing so, which is perhaps an interesting view. Next slide. So, who do the contractors see leading the trend towards sustainable construction? Quite an interesting one here. 70% of contractors said that the legislation would be the lead trend in terms of all of us building more sustainably. Interesting, they didn't think any of it would be encouraged by consumers or contractors themselves, and only a small proportion felt that clients and designers would lead to a more sustainable way of constructing. And I think that's probably true in a lot of respects, because a lot of projects in the end come down to viability, and if consumers aren't willing to pay more for sustainable buildings, then the clients are perhaps going to be more reluctant to embark on them. And I think the legislation changes will require all buildings to be more sustainable, and therefore all projects are on a level playing field. Next slide. This sort of a bit of an interesting question. We asked contractors whether they felt that the construction industry could ever be truly sustainable. Only 20% felt confident that it could be truly sustainable, and the other 80% felt that it was a possibility, or it couldn't be. 40% felt that it would never truly be sustainable. It's an interesting challenge for us, I guess. With any construction project, there is an element of raw materials that are used in the construction of any building or refurbishment, and how that will ever be truly sustainable is a challenge for all of us, really. Next slide. Okay, so what about the future? Is it a positive outlook? Interestingly, only 60% of the contractors felt optimistic about the future, compared to over 80% last year and 95% the year before. So there is definitely a sentiment that it's perhaps not as bright as it was. Contractors are still forecasting a significant growth in turnover into 2023 and beyond, but obviously not without its risks and further insolvencies. The war in Ukraine continues to impact on the construction industry, and these challenges don't appear to be changing anytime soon. I think on a positive, the construction industry has proven that it can adapt quickly to new challenges. We do have an ongoing skills crisis, and perhaps despite the challenges of COVID, Brexit and the war in Ukraine, the construction industry still continues to evolve and adapt to find a new way forward. And then the last two is just in terms of climate change. It's probably the biggest challenge our industry faces in the future, and building more sustainably, and the longer term economic impacts of the war in Ukraine and just general global markets. Next slide. That's it from me. The only thing I just wanted to pick up on was just one thing that I read on the Inside Housing magazine, which was saying that that we are currently facing 3 simultaneous once-in-a-generation events, with climate change, the war in Ukraine, and the COVID-19 pandemic, and how its impact on the global economy, materials, and general disruption. And just really, I think that's it's a success really that the construction industry continues to evolve and change and adapt to meet those challenges. So a credit to the contractors we work with. So that's all for me. So I'm just going to pass over to Sarah, who's going to be talking about some case law updates. Thanks.
Thank you, Tim. Good morning, all. We will now discuss some recent and hopefully interesting case law. First up is the case, and follows up nicely from John's last topic, regarding enforcement against a dormant company between WRB Limited and Henry Construction Projects Limited. Here, HCP were the main contractor, who subcontracted works to WRB for the development at the Fox's Palmer's Green in London. WRB served a notice of adjudication against HCP in respect of an unpaid interim application. HCP argued that in fact they had overpaid WRB and sought repayment. The decision of the adjudicator was that HCP was to pay the outstanding sum, but HCP subsequently did not make any payments and sought a stay of execution to allow time to formulate a counterclaim. Next slide, please. The oddity about this case is that WRB were a dormant company and in fact always been one, and disputed it was party to the subcontract. HCP argued this and stated that WRB were indeed a dormant company and said it was highly likely that any monies paid to WRB would not be repaid to HCP if HCP were successful in their counterclaim. Whilst the court agreed with HCP, it refused the stay of execution. The Honourable Mr Justice Pepperell, in his decision, stated that HCP chose to subcontract with a dormant company, and the inevitable consequence of having placed that subcontract with a dormant company is the result of which it contracted. It would be unfair and contrary to the spirit of the adjudication regime to allow Henry Construction now to escape its liability to meet an adjudication award on the basis of WRB's essentially unchanged financial position. Next slide, please. So, what can we take away from this? Carry out due diligence on the company you intend to enter contract with, or carry out searches or obtain credit references against companies whose financial status and standing is unknown. You could also consider some added security, such as a parent company guarantee or a performance bond. Next slide, please. So this judgment follows the recent Martlett versus Mullally case, in line with judgments dealing with the post-Grenfell tragedy and fire safety cladding related claims. I believe this is the only second judgment arising from such claims. LDC's claim was against two defendants. One was the subcontractor, a cladding specialist, European Sheeting Limited, and the other was the main contractor, George Downing Construction. The claim was in relation to numerous defects in the cladding elevations, which led to water ingress and fire stopping defects at 3 high-rise residential buildings in Manchester. Both LDC and Downing entered into D&B contracts and both issued collateral warranties in favour of then employer GWD. The warranties were then assigned to LDC and LDC made a claim under those warranties. Next slide, please. So LDC and Downing agreed settlement terms before trial, and it was provided that Downing was to pay LDC the sum of around 17.5 million in full and settlement of LDC's claims. ELC subsequently entered into liquidation prior to trial and served a defence in the proceedings but took no part. As I said, several defects were found in the external wall construction of the composite cladding. I won't go into all the details, but there were water ingress, there were fire barrier and fire and stopping issues in all elevations. The judge confirmed that Downing was entitled to full indemnity from ESL in respect of the sum, and that they were also entitled to further reasonable costs defending that claim. It was found that ESL were obligated under their subcontract to enter to agree with building regulations rather than using reasonable skill and care. ESL's claim for contribution and indemnity from Downing was struck out, and ESL were ordered to pay the costs for that claim. Next slide, please. So what can we take from this case? Firstly, the importance of using expert witnesses in supporting your claim. This case relied heavily on expert evidence, given the numerous defects. Make your contractual obligations clear under that contract and limit those obligations to reasonable skill and care under those appropriate clauses. And if you are a main contractor, appointing your supply chain on back-to-back terms are crucial. Next slide, please. So in the last case, we stressed the importance of expert witnesses and how heavily their knowledge and their expertise are relied upon. In this case, the judge was highly critical of this particular expert's, shall we say, strong personality. The case relates to a development at Pendrum Fields in Cornwall. The claimant is Barrett Holmes, who I'm sure you're all familiar with. Lantoom were the defendant, who were a local quarrying business and a supplier of stone. Lantoom were appointed to supply stone for the development, and 40 plus houses within that phase were built using the stone on the cavity walls. The judge was highly critical of Lantoom's expert, and he stated that he has expressed himself both in writing and in the witness box in trenchant language, and that repeatedly gave the impression that he knew better than everyone else, even when his position was a minority view or against the weight of the evidence. The lack of reflection and consideration of the weight of contrary evidence gave me no confidence in him, however forcefully he expressed him. The overall result being that the judge gave the expert's witness less weight. Ultimately, the expert's duty is to the court, and all experts should be measured and have a balanced approach. This is a rare case in that the judge gives a scathing feedback of an expert, and one that should be considered when preparing an expert with a strong personality and on the means and how to prepare them for cross-examination. Next slide, please. So, whilst this case law doesn't come under the umbrella of construction, I think it does highlight the importance of executing deeds properly. In this judgment, the meaning of in the presence of a witness was considered. As you probably know, deeds are legally valid by either signing as two directors or an authorised signatory, or a director in the presence of a witness. This case was in relation to whether a guarantee was validly attested. If the guarantee was a valid deed, ESL, the claimant, would successfully be able to claim with a limitation period of 12 years. Next slide, please. The defendants, however, tried to suggest that to validly attest a signature, a witness must include wording confirming that they have observed the act of signing, and they must also sign in the presence of the signatories. The judge concluded on the balance of probabilities that all defendants had signed the guarantee, and all of those signatures were witnessed, as in observed, by the witness, who then signed to say so in all of their presence. The judge stated that attestation involves more than simply witnessing the execution of the deed. It also includes the subscription of the witness's signature following statement that the document was signed or executed in his presence. Next slide, please. So, given today that contracts are more likely to be signed by e-signature, either by way of DocuSign or similar, I think it stresses the importance of a witness being physically present at the time that the contract is signed. We have seen many instances on DocuSign when the director or an authorised signatory has signed, but the witness hasn't signed for days or weeks later. Unfortunately, good for DocuSign, it has a record and we can check who signed in what location and what time. So it could be considered that the deed has in fact not been signed as a deed, but as a simple contract. So it's always good practice to have a contract signed and witnessed at the same time the signatory places his signature on the dotted line to avoid any unnecessary disputes in the future. Next slide, please. So for our last slide, we'll briefly discuss the recent statistics released from the leading mediation organisation, CEDR. I believe this is their 10th audit, and it found that 5.9 billion savings is around the estimated amount that commercial mediation will save businesses this year in wasted management time, damaged relationships and legal fees by earlier resolution of cases that would otherwise have gone through litigation. The survey also concluded that around 17,000 commercial mediations took place in 2020 alone. And the majority of mediators did not encounter issues in relation to mediation settlements, and 64% of commercial cases were conducted online. And there is no indication that success rates are lower without the pressure of being sat in a small room all day with only your lawyers to talk to. The audit also stated that 92% of commercial mediations settle, 70% on the day and 22% shortly after. So that's all from me on the construction case law roundup, and I will now pass you back over to Catherine with the Q&A session. Thank you.
Thank you, Sarah. So thanks to all our panelists for those really useful comments. We've had some questions. Thank you very much for those. And in particular, I think there's been a lot of interest in Tim's discussion. So I've got a couple of questions for you, I'm afraid, Tim.
Oh dear.
The first one was about an interest in hearing about any comments regarding the cladding crisis and how this is playing out for construction companies at the moment. Obviously quite a topical one.
It is, I guess, sort of under the Building Safety Act. We did actually ask the contractors a couple of questions about that in the survey, which we didn't put in the results. We did ask them whether they thought it would have a negative impact on their business, and over half of them said that it would have a negative impact in terms of lack of availability of cladding and resource and labour again. So it will add further pressure onto an already pressurised market.
Absolutely. And just picking up on another point you raised, you mentioned that single tendering was not the preferred option, and there was a question around what is preferred at the moment by contractors from the comments you received.
Yeah, I guess ultimately a contractor would probably select a direct negotiation if they had their way. However, I think what we're seeing a trend towards now, and has been for a little while, is two-stage tendering, where there's an element of competitiveness in terms of sort of tendering the prelims and overheads and profit, and potentially a small proportion of the works. However, the second stage of that two-stage process is a far more collaborative, open book process, and I guess the key to that in terms of how you might mitigate price rises or uncertainty is that you have that transparency with the client where they can see the package costs coming in, and if a contractor is truly open and honest with that process, then you do kind of de-risk a project through that process.
Sure, thanks. And there was another one for you around tendering as well. There was a comment about the disparity between QS estimates and tender returns that then come through, and a query about whether this is a bit of a wider issue and whether the QSs are struggling to keep up with the current market.
Obviously, I say we're not, but no, it's seriously though. It is obviously a challenge. I mean, what you can see perhaps in the presentation, prices are fluctuating significantly, and they change week on week. And I guess the answer to that is keeping on top of your estimate in terms of checking with contractors and supply chain partners in terms of those prices, but equally updating them regularly. I think what you can't do now is complete an estimate and park it for 3 months and just adjust it regarding with BCIS. I think you really have to go back and look at each of the elements and see where those might have changed. I think the other probably cautionary tale as well is that BCIS has changed their outlook and forecast significantly even over the last couple of months, and it's just keeping an eye on what they're saying, but also talking to your contractors you're working with in terms of what they're actually seeing on the coalface, because I think that what we're seeing from this survey is that prices are rising faster than perhaps BCIS are suggesting and have done.
Thank you. John, if I can come to you, there's been a couple of questions around adjudication. One of those is what happens if the adjudicator orders the other side to pay the costs, but they can't or won't do so?
Okay, so the adjudicator has jurisdiction to order how his costs are paid, but ultimately both parties are jointly and severally liable to pay those costs. So the adjudicator is likely to come after the better target for them if they find themselves not being paid after some time. Also, it's worth saying increasingly we're seeing adjudicators ordering costs to be paid by the winner and then recovered from the loser anyway. So adjudicators are very live to that. Also worth saying that the court is generally supportive of adjudicators and will help them to enforce the adjudicator's costs pretty quickly, similarly to the enforcement of the decision itself. So if an adjudicator does want to recover their costs from you, it's going to go along a fair lick.
Yeah, thank you. And again, on adjudication, we had a question around if you've commenced the process, do you have to see it right through, or is there any way out?
There's always a way out. If you're the referring party particularly, you can always withdraw. It's unusual to do that, but there are circumstances where it happens. More likely is that the parties midway through the adjudication find a way to make the decision themselves rather than leaving it to the adjudicator, come up with a commercial solution that works for everybody. Perhaps even undertake a mediation partway through an adjudication. If you can find the time for it, that does sometimes happen. If you need to, you can always stop the adjudication. I think the key thing to say is that the adjudicator is going to want to be paid. So if you let it get too deep into the adjudication, that can become a stumbling block to settlement in its own right, because you'll have to work out who's going to pay those costs as part of the settlement.
Absolutely. And you mentioned mediation there. Obviously, we had those statistics at the end there, which are quite interesting about the number of mediations and the prospects for settlement. Another question that's come up is whether you can be obliged to mediate.
You can. So some contracts do have compulsory mediation provisions in them. I mean, you have to mediate before you can take another step in the dispute resolution process, whether it's litigation, arbitration, whatever. Even if you don't have that, there is a fairly sizable risk if you refuse to mediate. Parties who unreasonably refuse to mediate open themselves up to the court's wrath, which is generally expressed in terms of costs.
Yeah.
Might mean if you lose, you get a higher proportion of the costs ordered against you, or if you win, you might not recover your costs, or in the worst case scenario, you might end up paying part of the other side's costs even though you beat them.
Yeah.
So it's a brave party who just says no blankly.
Definitely. The court's very keen on all forms of ADR at present, aren't they? Thank you. So I'm conscious of time. I think I'm going to have to wrap it up there. Obviously, any other questions we haven't picked up on, we can pick up individually. Thank you for those. I hope you found this morning's session useful. When the session ends, you'll be asked to submit a feedback form, including any suggestions you might be interested in for future sessions. So if you can complete that, that would be really helpful to us. And a date for your diary, the next one of our webinars is our summer webinar, which is on the 29th of June. So we'll put out information in relation to that in the coming weeks. So finally, thank you all for joining today. Have a good day, and we hope to see you at the next webinar. Thanks very much.